You're listening to podcasts from the Congressional Internet Caucus Advisory Committee, www.netcaucus.org.
Good afternoon, everyone. My name is Miranda Bogan. I'm a policy fellow at the Congressional Internet Caucus Advisory Committee, and we'd like to welcome you to our briefing today entitled, Will Frivolous Lawsuits Be the End of the Internet? This event is hosted in conjunction with the Congressional Internet Caucus, and we'd like to thank our co-chairs. On the House side, it's Congressman Bob Goodlatte and Congresswoman Anna Eshoo, and on the Senate side, Senator John Thune and Senator Patrick Leahy. So thanks to the caucus for co-hosting with us. Just a little bit of housekeeping before we get started. The Twitter hashtag for today's event is SlapTalks with two P's, SlapTalk. If you want to tweet or follow along. And the Twitter information for all the panelists or their organizations are on your program. We've also got a number of events coming up this month. Next week we have an event on music streaming, so you should come out to that. And we're announcing more throughout July and maybe a little bit into August. And so with that, I want to introduce our panel, a great panel, very experienced on this issue. We have Amy Austin, who's the publisher emeritus of the Washington City Paper. And next to her, we have Laurent Crenshaw, who's the head of federal public policy for Yelp. Right down the line is Jenny Rasmussen, the senior policy counsel at the American Association for Justice. And at the end, we have Kevin Goldberg, who's an attorney at Fletcher, Heald and Hildreth. And we're looking forward to hearing from all of you, and feel free to jump in even if I direct a question at any of you individually. So defamation suits and other suits of that nature have traditionally been an issue that's dealt with by journalists, but with the rise of sites like Yelp, Glassdoor, TripAdvisor, Facebook, where people are reviewing businesses, it's come more into a situation where individuals are at risk of being sued by those companies or individuals about whom they're writing on those platforms. So while media platforms might be prepared for those types of suits with insurance or legal teams, individuals are often intimidated by these types of lawsuits. They're scared of the cost of these drawn-out legal processes, and they are intimidated to take those reviews down. And not only them, you can imagine that other people might think twice about speaking out against such a business if they see someone else getting dragged into a lawsuit. So we have this chilling effect of freedom of speech online. So that's what we're talking about today. SLAPP suits, or strategic lawsuits against public participation, is the terminology for it. So you might hear that term getting thrown around today quite a bit. And recently we have introduced the Speak Free Act of 2015, which was brought in May by Representative Farenthold and Eshoo, and has a number of co-sponsors at this point. So we're going to be talking about that, both unpacking a little bit of the legal and procedural issues, but also talking more broadly about what this means for freedom of speech online writ large. I want to remind everyone in the audience that the advisory committee and the caucus don't take any positions on issues, so we try to have balanced discussions as possible, so I might play devil's advocate a little bit, and again, feel free to jump in, ask questions of each other as well. And with that, I'd like to turn to Kevin, who has done a lot of work in this case, to talk broadly, like, what are SLAPP suits? In plain English, why does this matter to people?
Well, thanks. My name's Kevin Goldberg. I'm an attorney for the law firm of Fletcher, Heald and Hildreth, and among my clients are the sort of old school SLAPP subjects. The American Society of News Editors is one of them. The Association of Alternative News Media is another, and that's a membership organization that includes the City Paper. I'm also on the board of what's called the Public Participation Project, which is an organization dedicated to raising awareness about anti-SLAPP statutes and SLAPP lawsuits. So I'm distinctly not unbiased on this issue. I clearly have a position that anti-SLAPP statutes are a very important protection of free speech. And why is it that you should care? Well, we'll hear a very personal story, I'm sure, from Amy, and I actually have some backup if she doesn't get to the part I really want to tell that shows you just how egregious this can be. But it really does affect everybody, and I think that's something to know when we're sort of focusing today with regard to the internet, is that's the biggest change in the last 5 years. It's not like SLAPP lawsuits have come around in the last 5 years. They've existed forever. It's just that sort of the game has changed with regard to SLAPPs, where everybody is now, of course, able to reach out to the entire world. And the reason the anti-SLAPP statutes are important are that they level the playing field for you or I when we say something critical about somebody that's bigger than us, more powerful than us, has more money than us. I said I've worked primarily with media organizations, and a lot of them obviously don't want to be sued. It's a drain on their time. It's a drain on their resources. It's emotionally stressful, even if you know you're going to win. Even from a lawyer's position, I get stressed out when I have a client, threatened with a lawsuit. I'd love to be one of these guys that sits here and, you see in the movies and, oh, forget this. We'll get that tossed out of court in days. It's not a problem. You're going to win. That's not real life. Real life is you get a lawsuit, the clock starts ticking with regard to your attorney, at least if you have one more generous than me that may, unless you have one more generous than me that may not charge you for defending them. But lawyers aren't cheap. Time isn't cheap. Every minute you spend defending this with your lawyers in deposition, in court, is a minute you are not working. Every dime you spend going there is a dime you're not spending somewhere else. And all this to defend what is in most instances a frivolous lawsuit designed to do nothing more than keep you from criticizing somebody else. That's why it's so important, because you may win the suit, but it will take its toll. And these suits, these statutes, the anti-SLAPP statutes that exist in just under 30 states, but not in federal courts right now, and not in every state, and certainly not within the federal court system. It hasn't fully been recognized in every case that's gone to federal courts. Give you that ability to knock out the frivolous suit more quickly, and in some instances, actually get your fees paid for. So again, a big corporation brings a suit against you. Great, you may win, and they may know this, and they may understand it may get knocked out quickly. They've taken up your time and some of your money. But they might think twice if they actually have to pay you for that time or money. So that's why this is really, really important for everybody.
Amy, maybe you'd like to talk a little bit about your experience.
Sure, I can chime in now. So I'm Amy Austin. I'm a publisher emeritus of Washington City Paper. So as Kevin said, City Paper is one of a local what's called local alternative media. There's about 113 papers, media companies like City Paper across the United States. So our job, our focus, our passion is to cover local news. So we cover local news and culture for cities across the United States. These companies are part of this association. So City Paper, Washington City Paper, which is your local news source, was sued. We wrote a fantastic story. So let's start at the beginning. We wrote this incredible story about the Redskins. And it was called The Cranky, this is like full of, let me get the name right, because it's Cranky Redskins Fans Guide to Dan Snyder. So this was in the fall of 2011, and it was published right after a big loss to the Philadelphia Eagles. There was a Monday night football game, and we, completely screwed up the game. And then that Thursday we came out with this piece. And there's a sports writer named Dave McKenna who wrote it. And he just took all his knowledge about Dan Snyder and the Redskins and all the ways in which he had wronged the team and the way he had spent his life and wrapped it up into one very funny guide. The piece stands the test of time, and everything in it was accurate. So, it got sort of normal play at the time. Like when we published it, people enjoyed it. There was some talk about it. But then we soon after got a letter from Dan Snyder that famously said, and this is sort of the money line, and it was sent, we were owned at the time by an investment firm called Atalaya. So I think this is an important part of the story too, is that our ownership was, in flux. So he wrote the letter to an investment firm. As Kevin said, media organizations were aware that we can be sued at any time. It's part of the business. We're aware that we want to get everything absolutely right. all the time so that we don't get sued. But what happened here was the letter initially went to the investment firm, and investment firms do not like to get sued, turns out. But in the letter it stated, Mr. Snyder has more than sufficient means to protect his reputation. We presume that defending such litigation would not be a rational strategy for investment firms such as yours. Indeed, the cost of litigation would presumably and quickly outstrip the asset value of Washington City paper. So what he's saying is that he could quickly outstrip the value of Washington City paper. So his intent was to put us out of business. That's why we're here today. So that there was an anti-SLAPP law in D.C. at the time that was relatively new that led, presumably, for him to drop the case against us. But this is a classic case of a Goliath, after a small media organization. And it was a very, very difficult, trying time. I mean, what they wanted was an apology, which I wasn't willing to give because we had nothing to apologize for. What they wanted was a retraction. There was nothing to retract. We didn't have any, there was nothing wrong with the story. Or they wanted us to, this was, I think they would have been pleased if we had fired the reporter. I don't think that was ever expressly stated, but that's the sort of things that were at play that we had to defend for over a year.
And so that's the sort of media side. That's what we kind of expect from defamation suits. But now with the internet, we have individuals who are the targets of these suits. So maybe, Laurent, you could tell us a little bit about how that's changed with review sites, with the proliferation of online platforms where people can write really whatever they want, but may not be thinking about what they're writing and the consequences of that, and how they might be able to defend themselves.
Sure. So again, I'm Laurent Crenshaw, head of federal public policy at Yelp. And if you haven't heard of Yelp before, Yelp is a website that connects people to businesses and places that are around them. Currently has about 142 million unique monthly visitors and is in 32 countries. Started 11 years ago in the city of San Francisco. And as a part of that process for the mechanism for connecting people to local businesses around them, it also has become a site for aggregating reviews and assigning ratings to the particular places and businesses that you might go to. So, for example, we're here in Washington, D.C. right now in the Rayburn House office building. I think that the Rayburn cafeteria has like about a 2-star rating on Yelp with like 5 or 6 reviews. Yeah. So it's just, whether it's restaurants or dry cleaners or plumbers or businesses in general or places in general, they have a Yelp page, generally speaking, and ratings that are there. And it doesn't just apply for Yelp, though. You also have sites like TripAdvisor, which are for travel and sort of hotels and things all around the world. You have ZocDocs, which is a site that's come up for doctors and finding out the best doctors that might be around you. Google does it as well with their Google Plus results and reviews that are there. So, and even Facebook as well. If you go into a business page for Facebook now, you'll see ratings for businesses and people will leave reviews and opinions. So really, with the rise of social media platforms and the internet, there's also been the rise of the review culture that Yelp has really sort of been at the front of, which is where individuals have had the ability and opportunity to share their opinion, to share their fact-based experience with a particular business or with a particular place, and they do it really for the greater sort of community service, for the good. Why do I go on to Yelp and rate a particular business? It's not because I'm receiving any sort of compensation or anything out of it, but it's because I want to let everyone else on the internet, my neighbors and others know my the experience that I had there. In the past, you might ask your neighbor, you might ask your friend, use word of mouth as a means of really figuring out what's the best of what's around you. And now, thankfully, we have the internet, so we can get this broader, more aggregated experience out of it, and to make better purchasing decisions or just make better decisions in general. But along with that, obviously, when you have a platform and the internet in general, which is really this bastion of free speech, of where you can go and sort of express your opinions in the First Amendment, or under, just in general, but that's protected by the First Amendment, you are occasionally going to have circumstances and times where people won't necessarily tell the truth. It might not be a fact-based experience, but in general, under those circumstances, platforms like Yelp, TripAdvisor, and Amazon, and so many others already have within their terms of service mechanisms and tools that allow those types of statements and reviews to either be flagged or for business owners to respond. And so really, the ways that the platforms work, it helps to ensure, especially in the case of Yelp, that it is an honest first-hand experience. Now, a lot of people might think also that review platforms are places where people kind of go to complain, that they go to just sort of leave a bad experience about it. But at least in the case of Yelp, we found that about 75% or so of the reviews are actually 3 stars and above. And so, you might think in your head that it's, I'm going to go there and, really ding that business that didn't give me good service, but oftentimes it's people that are going just to actually share their experience with sort of the greater internet society. And so I say all of that because you do, at times, unfortunately, have instances where business owners or individuals have not agreed with the statements that have been made about them. Amy mentioned it from the standpoint of the city paper. Well, just look at the internet, platforms like Yelp or Facebook or others as basically being, it's online, it's digital media. So it's like a continuation of that. And unfortunately, some business owners have decided to go the route, or individuals have decided to go the route of either threatening or actually attempting to sue people based off of whether it's a Yelp review or a TripAdvisor review or ZocDoc opinion. And the fact of the matter is that most of the time, these are individuals' first-hand experiences or opinions. It's like, I went here, I experienced this, it wasn't up to maybe it was a bad experience, and you say it was a bad experience, but generally it's still your first-hand opinion. But unfortunately, you have this group of individuals that sometimes decides to use litigation as a response rather than actually trying to engage in better customer service. And that's what we sort of saw this happening, and it's continued to happen. And what we worry about, though, obviously, and why we've been a big supporter of anti-SLAPP legislation, is that while we know, and as Kevin said before, that most of these lawsuits, the people that are actually out there trying to either threatening to sue or actually going forward and suing someone, and it's sort of falling under this mantle of a SLAPP suit, they don't necessarily expect it to go to trial. They don't necessarily even expect to win if it does go to trial. But what they're hoping is that you'd rather remove your Yelp review or remove your TripAdvisor review and never speak either ill or anything at all about that company again, rather than expend the thousands of dollars or the tens of thousands of dollars to actually defend your statement in court. And, you might think about, like, man, is my, review of the Longworth cafeteria really worth, or maybe Longworth's not a good case because it's a governmental entity, but say, if we were talking about, what's a good, 18th Street Lounge, I don't know, a place in D.C. Is my review of 18th Street Lounge worth, potentially tens of thousands of dollars in litigation and defending it? Unfortunately, most people, most of the time, if you're an average citizen who just decided to share that opinion, you're going to say, no, it's probably not worth that. I'd rather take it down than have to go through that whole process. And one, we obviously feel that that's wrong because you have the right to be able to share that opinion, your honest, fact-based opinion, and it is protected by the First Amendment. That's sort of the first point there, that it is protected. And then two, we also, are concerned from Yelp's standpoint about the overall chilling effect. Because even if it's not you, if you're not the one who's actually experiencing that suit or that threat directly, if you tell your friends about it, or if you say it to someone else, well, I got threatened with a lawsuit based off of my review of a restaurant, then it poisons the internet ecosystem as a whole. And, we all, again, look at the internet as really being this bastion of freedom of speech where you can go and share your opinions, share your, your experiences. And so we as Yelp in particular worry about slap suits really, really infringing on your ability in that experience.
Actually, it's funny. I was just thinking of something. I don't really mean to hog the mic, especially since you haven't been able to speak yet. But one thing that we've talked a lot about people who might stop and think before they say something, and the fact that an anti-slap helps you, continue through with that thought. But what about the times you don't even stop to think? I mean, how many of you don't actually have to show hands? You can just nod your head silently, and everybody's done it. Have been so angry at something that you turn to Twitter and rant. You don't even think. Oh, my flight was delayed again. You suck. Insert airline name here. Dear cable company, your guy was supposed to be here at 5. It's 6. Not effing here. You've done it. You've all done it, and you haven't even thought. It's probably protected. A lot of this stuff is protected. It's not defamatory. And they're not, for public relations reasons, they're probably not going to sue you. But what if they did?
Hi, as Miranda said, I'm Jenny Rasmussen. I'm here representing the American Association for Justice. Some of you probably know us, but if you don't, I'll just give you a brief overview. We are the world's largest trial bar, formed in 1947. We are committed to ensuring that, we're committed to ensuring that all people, individuals, consumers, families, patients, workers, have access to our courts in order to enforce their rights. So, when we're talking about slaps and how to define a slap, I agree with much of what the rest of the panel is saying here. I want to highlight 2 points that I think you should think about in how we define slaps, because this becomes important. One, they're meritless lawsuits. The person bringing them has no expectation that they're actually going to win in court. They're bringing it to bully and harass and silence someone, and that's wrong. And you don't have a right to bring frivolous things in a court of law. Second is that usually, except with some larger media defendants, I would say usually there's a disparity in resources between the two parties. The person bringing the slap lawsuit has tremendous resources. They can make frivolous filings in a court of law, which might be sanctionable because they can pay for them. Whereas the David in this situation, the smaller litigant, that is a serious economic threat to them to have to defend against something like this. So I think those 2 points are really important, and I stress them because in how we define a slap lawsuit, those 2 points sometimes get lost. And I'm here today, I think, because I'm going to be presenting somewhat of an opposing view on the bill that was introduced, the Speak Free Act. Not because I disagree that there's a concern here and something should be addressed, but I disagree with the way slap is defined in it. And we have serious concerns that as it is defined very broadly, that it's going to apply to a lot of lawsuits that you don't intend it to apply to, such cases as whistleblower lawsuits or civil rights lawsuits or key TAM security lawsuits, a lot of lawsuits that arise out of statements that are by nobody's imagination something you would consider a slap lawsuit.
That's a great segue to talking about the state of legislation. We have about, I think, 28 states and Washington and a territory or two that have their own anti-slaps legislation, but they're different in each state, right? Some of them are very broad and some are quite narrow. And then we have this new federal legislation, which we've had in the past, and this one is, I'd like to hear from the panelists, how is it different from past legislation? How does it differ from the state legislation? What's the purpose of introducing it at the federal level?
I'll start off a little bit. From our standpoint, there's need for federal anti-slap legislation, in particular because given the sort of the nature of the internet in general, you can oftentimes have circumstances where you have parties that are in different jurisdictions, and so that's often obviously something that would really necessitate itself more so to the federal side rather than to the state. And then also because of the differences in the nature of the state laws that are in place. So there are 20, as you mentioned, sort of 28 states that have an anti-SLAPP law on the books. Some are really good, like the state of California's, or the state of Texas's. They have really good anti-SLAPP laws, and I believe that the Speak Free Act itself was actually modeled on those two pieces of legislation. But then you have states like New York State that actually doesn't have a very good anti-SLAPP law on the books, that's relatively narrow in regards to its scope. I believe the same in Pennsylvania. And so what you sometimes end up have happening is that there's forum shopping where basically if you're a party that's looking to sue someone for sort of make a SLAPP motion based off of, make a SLAPP motion based off of a statement that's made online, you look to see either if you can find a state without an anti-SLAPP law on the books or one that has a relatively weak one. And so from a Yelp standpoint in particular, when you're looking at statements that are made on the internet, having a federal standard, at least baseline standard for when it comes to First Amendment anti-SLAPP protections, we think is really crucial to ensuring that the speech and statements that you make online is protected.
And just to pick up on a couple points, one more example of, for instance, a state law that's now recently been changed that is narrow is Florida, which only applied to lawsuits brought by government officials against a private individual, and that's now been broadened within the last year to give more protection. I mean, you do have other states out there. You mentioned certain stronger and weaker, and Maryland has a really weak anti-SLAPP law right now. Virginia has none. And D.C. has one, which is another reason I think we need this federal, that has recently been held to not apply when you're in a federal court proceeding. And so you have this big gap, and it's kind of like I'm a defendant in D.C., I'm Amy, and Dan Snyder decides, well, I'm going to sue as a resident of Virginia, and I'm going to do it in federal court because now, based on this recent court ruling, and it's not just D.C., I think there's one out of Washington as well, now that the federal court can't apply the anti-SLAPP law. So there's this huge loophole that's been created that's undercutting the state laws. And that's why we need this legislation to fill in the other states that don't have them, hopefully, and also fill in the protections that exist in some states that do.
This is actually relevant in our case. The suit was initially filed in New York, which, as you heard, didn't have as good a law as D.C. for the anti-SLAPP, and then the case was moved to D.C. So I felt much more like I had a club in my hand when the suit was moved to D.C. Because there was an anti-SLAPP law here to help protect against these frivolous lawsuits.
So when we talk about what the states are doing, there are about 28 states that have some kind of SLAPP law on the book. They all vary, and I think that echoes the point that there's not consensus on how to define a SLAPP lawsuit. Some are very narrow, like Pennsylvania's, that only apply to environmental issues, or some are quite broader, like California. But even California has this language in its statute that it has to be an expression made in furtherance of your constitutional right to petition or free speech. That language is notably absent in the Speak Free Act, the bill that was introduced in Congress. Also notably absent from any state bill is any kind of change in state versus federal court jurisdiction. Something that I think is really extraordinary in the Speak Free Act, it actually has a removal provision to remove state-based claims filed in state court to federal court, even when there's not diversity jurisdiction. That is extraordinary to me. So it's one thing to have a rule to apply to help litigants who are in federal court because there's diversity of citizenship, and thus that's why they're in federal court. It's quite another to tell states, we're taking these cases out of your state courts and putting them in federal court because we don't trust your judgment. So I think when we talk about this issue, it's important to remember that our Constitution is based on a system of federalism. What our framers did not specifically authorize for the federal government, they left for the states, and that's forever preserved in our 10th Amendment. So you ask yourself, all these states have passed different SLAPP statutes. Some have considered and decided not to pass a SLAPP statute. Some have ruled their SLAPP statutes to be unconstitutional. Others have tried to draft very narrow SLAPP statutes. What happens to those if you pass this big, broad federal bill that removes all these cases to federal court? They're effectively preempted because you can remove them to federal court. There's no longer a state statute that applies to them in the state court. So that's very troubling to us because the issue of tort law and all the sorts of cases you hear about, whether it's product liability or medical malpractice or defamation, that all exists because of state law. There's no federal tort law. It's a state cause of action. And the Speak Free Act kind of changes that, because you're telling them now that it's something that belongs in a federal court. In addition, what I wanted to say is that
and then I want to jump in from I think we
Right after you.
Yeah.
So there is this problem when you look at what states are doing and what they've decided to do, including the states that have ruled it to be unconstitutional. What are the unintended consequences of putting a very broad federal bill that preempts all of those? And that's where our organization comes in with its opposition. We think that there are significant concerns that, as written, the bill is going to apply to the cases I just listed to you of individuals, not the Goliath who's bringing frivolous lawsuits, but the David who's going after a Goliath in a whistleblower action, in a civil rights action, in an employment discrimination action. Those kinds of cases are the ones that we want to help protect and preserve. So I know that a lot of people probably want to comment.
Great. I'll just, jump in response to a few different points that Jenny made. I think that we fundamentally differ already in regards to, she described it as being overly broad. There are specific exemptions and exceptions for particular areas that are already within the bill, and particular limitations, whether it's dealing with commercial parties, whether it's dealing with statements that are made about governmental actors, statements that involve whether state or federal, and then also those that are made about sort of environmental and other areas. The bill itself is really, we think, narrowly tailored in the scope in regards to the conversation that it's dealing with. Now, obviously, when you're talking about the question of what is a SLAPP suit, there are a lot of things that could be deemed or considered SLAPP suit, but that's because it ultimately comes back to one particular area that we've been talking a lot about up here, and that's the Constitution and your First Amendment right to speak and to be protected in regards to what you say. If you're making, a fact-based statement, if you're sharing your opinion in a manner that's not defamatory, and I'm not going to go down the road of what's, defamation, because it's pretty clear, and just like at the federal level, and it states what the standards of defamation are. And so what we're really talking about here is whether or not, if you're in an area that either doesn't have an up-to-date law in the books, because really it's just the fact that anti-SLAPP laws in general haven't kept pace with the speed of the internet, of how far along we are in regards to how communication happens, how people express their opinions online, and in many instances state laws haven't caught up yet. So even within those 28 states, yes, there are differences, and then the other 22 states that don't have a law in the books, but the real sort of question is that, we're not talking about all of those claims being immediately removed to federal court and being on the onus of federal judges to deal with. It would allow for removal. So it would basically say, okay, you're in California. California's got a great anti-SLAPP law in the books. Why would you bother filing a claim in federal court in that instance if it's a state-based matter? But if you're in Arkansas, where there isn't an anti-SLAPP law, but you're being hit with something that is on its face, a SLAPP suit, then this would allow for the opportunity of removal to the answer of that question. Is it something that going through, looking at it, that it's on its face would be, when you file your pleadings and you sort of say what's happened and, as a defendant, and you make this motion, that in a very expedited process you can figure out, okay, this is a SLAPP suit, that a judge can figure that out and throw it out in that case, or at least on that point. And then because of the fact that a SLAPP suit was filed against you and you've had to expend thousands of dollars, if not tens of thousands of dollars in attorney's fees, then at least have the other party pay that off or provide some sort of compensation so that you're not left, one, with your speech having been threatened, two, with your time having been taken away, and then three, with tens of thousands of dollars in attorney's fees afterwards. And so that's why we feel that this is really important, and why, in particular, we support the Speak Free Act, and we don't think that it's overly broad. We actually think that when you're talking about what a SLAPP suit is, which is basically a meritless lawsuit that infringes upon your First Amendment right to free speech. And the fact of the matter is, a lot of speech happens on the internet. Don't get me wrong, a lot of speech happens there, but it should receive the same protections as someone like Amy received, or the city paper received, because what they did was in print.
I'd like to follow up on that with something that I don't think we've been quite clear on, which is the effect of the special motion to dismiss that exists in the Speak Free Act. All right, so it's not, we really need to be clear about this. It's not as simple as I'm the defendant, I've been served with what I believe is a frivolous lawsuit, and I file my motion to dismiss, and then this all goes away. You know, if I can show that my right, and specifically, the bill allows me as a defendant to file a special motion to dismiss if I've made an oral or written statement or other expression that was made in connection with an official proceeding or about a matter of public concern, and then there's certain exemptions. Well, that's actually very similar, I think, to the California law, where you talked about a statement made in furtherance of the right to petition, which both, in fact, are at the core of the First Amendment. So what I do as a defendant is I show that I've made this type of statement. That's my first response. But that's not the end of the case. I don't win there. What happens is now the plaintiff still gets his or her, its bite at the apple. The difference now is their standard has risen. Okay, now they have to show that the lawsuit in question they have to show that the claim is likely to succeed on the merits. And yes, is this harder? I think so. Clearly it is. But the point is they're not kicked out of court. And I think this is important to remember, because what it does is if I'm a defendant and I make a statement and I'm sued and otherwise I would back down, you know, that's a big burden. Now this shifts the burden to the person bringing a lawsuit that would otherwise restrict my constitutional right to free speech. And we do this all the time in First Amendment lawsuits. That's the core of the number one biggest First Amendment lawsuit that people who haven't even gone to lawsuit know, say it with me, New York Times versus Sullivan, was all about shifting the balance from one side to the other, recognizing that certain truths might, we want the truth to come out, and inevitably we'll hear certain falsehoods. Well, the opposite decision the court could have come to is we want to keep all the falsehood out. So we're going to, in effect, keep some of the truth out. It's a balance shifting, a burden shifting, and that's really what I think this bill does.
So I agree. It shifts burdens, this bill. The question is, are you only burdening people who bring slap lawsuits? And the answer is no. It's burdening people who have legitimate, worthy lawsuits who are now going to have to fight these slap motions. And I think that the most illustrative of this is the use of a slap statute gone bad. I'm sure some of the people in this room have seen the HBO documentary Going Clear. There was a woman featured in that documentary, if you remember, named Monique Rathbun. Do you remember her? She brought a lawsuit against the Church of Scientology. And if you're a legal geek like me, you look up what happened to her cases after watching that documentary. But this is what happened. She brought a very legitimate harassment lawsuit against the Church of Scientology. She was never a member of the church, so she could bring this lawsuit. The Church of Scientology has used Texas's anti-SLAPP statute to cripple her case. So even in cases like Monique, where she can meet this burden, this much higher burden of proving that she has a legitimate case, the judge agreed with her. He ruled against the Church of Scientology. Her case has been on appeal for over a year now. She's never had a chance at discovery, just the basic elements of building her factual case. If the Speak Free Act was law, not only would she have that burden, but her case could have been removed to federal court and likely would have been removed by federal court, because it would have given the Church of Scientology the right to remove that case to federal court, where I'm sure her appeal process would be even longer than the state of Texas, just because of our judicial vacancies and overburning of our federal court. So I think when you think about, yes, it is shifting the burden, that's exactly the point we get at when we say that you shouldn't strengthen the constitutional rights of some by violating the constitutional rights of others. And that's why the Washington State Supreme Court struck down its SLAPP statute, saying that their statute is unconstitutional. And I'll read a great quote from that. I actually love this opinion. Basically saying that the legislature may enact anti-SLAPP legislation to prevent vexatious litigants from abusing the judicial process by filing frivolous lawsuits for improper purposes. We agree. The constitutional conundrum that the SLAPP statute creates is that it seeks to protect one group of citizens' constitutional rights of expression and petition, what we're all talking about today, by cutting off another group's constitutional rights of petition and jury trial. This a legislature cannot do. I'm submitting to you that it's true for Congress as much as it was true for Washington. Congress cannot pass a law that protects one group's constitutional rights at the expense of another, most notably your right to petition under the First Amendment to our courts for a real grievance, and your right to a civil jury trial under the Seventh Amendment.
Kevin, did you have a response to that?
I guess I just want a clarification. Are you saying that you think the Speak Free Act would be unconstitutional?
Yeah, we believe it is subject to constitutional challenge, is written.
Unless you want to.
Go ahead.
Well, I mean, I recognize this is a very broad bill. There's no doubt about it. And again, it doesn't, the issue I think you're making with regard to the appeals is one of interlocutory appeal, which is provided in this statute. And that allows someone, even when the case isn't resolved, to go to court when a key issue, to go on appeal when a key issue has been resolved. And that exists in a lot of First Amendment lawsuits and has existed for years. I lose on a motion for summary judgment on a key issue, and I can immediately go to court. And there's a reason for that as well, because I, as a defendant, in an anti-SLAPP, if I have to then immediately go to discovery, even though I think the key First Amendment issue of my having been slapped has been answered the wrong way, then of course the penalty's on me. And I think, as a plaintiff, you make these decisions all the time. As a defendant, you're reacting all the time. And it's very it's a very different position to be in, to have to be reacting and versus making the choice yourself to say, I'm going to go to court, and I understand what this means. But otherwise being drawn in like Amy and forced into court with then the fight ahead of you for so long.
I'd like to bring this back, and you can follow up in the answer to this question, I think, to the internet, where in Amy's case, you knew who was getting sued, but on the internet, you often have people hidden behind usernames or some kind of anonymizing screen. So what happens in that case? Does the bill address that? Do those people have the right to anonymity, and where do the platforms come into play?
Sure. So I'll try to respond to a few different things. I think in regards to Washington State specifically, you have to look at that decision by the state Supreme Court in the Washington State microcosm. They were responding specifically to the Washington State Constitution and what was specified there, and that there were issues of concern in regards to how the bill had been drafted to being conforming to the Washington State Constitution. So, and again, we disagree with the AAJ on the point of that applying on the federal level. We don't think that they're the same concerns that are raised. And in regards to infringing upon the rights of individuals to make these types of petitions and claims, let's sort of put this a little bit more into context, or at least what I think is in the context. If you're suing someone for defamation, generally speaking, you're either a business of some kind, or you're probably a public figure. These are the types of people that we're typically talking about that are, filing these types of suits. Is it eliminating their ability to file this type of suit? We've already established that this bill is not, that it raises certain procedural and sort of, procedural or processes in regards to the substantive question of whether or not you're violating the person's First Amendment right. But generally, at the end of the day, we're talking about either a business or someone that has the resources available to use them to intimidate you with a meritless lawsuit. Whereas on the other end here, I have, I think, like 12 people or so on this page. So, for example, a woman, Katie M. from Chicago, who wrote, a review on a window shade company and then ended up getting a SLAPP suit filed against her. Or Zaki Ibrahim, who had a negative experience with ZBAC auto trading and got a SLAPP suit that was filed against him. Or Elise Goldberg, who was sued by a Beverly Hills dentist about a negative Yelp experience on Yelp. So what do these people have in common? That they wrote about their experience on Yelp. We're talking about instances in dealings with a dentist, in dealings with a doctor's office, in dealings with an auto company, with a window shade company. It kind of goes to the point that you can have SLAPP suits that deal with the whole breadth of different issues and things. But ultimately it comes back still to that sort of First Amendment question of whether or not your speech is being infringed upon. But to the second point, and to your question, Miranda, in regards to anonymity, in that sense, Yelp fundamentally believes that and also we think that it's been proven time and time again in courts, that individuals have the right to anonymity in regards to statements again, fact-based statements or experiences that they make about a particular person, thing, or business, or, especially on the internet. And where this really comes into play is, let's say you had a bad experience with a doctor. Maybe you're a man and you went to a doctor about man things, or a woman and you went to, a gynecologist and whatnot, and you had a bad experience, and you want to share that experience, but obviously it's about a sensitive matter, or at least area of medicine, so you don't necessarily want to attach your name to it. Yelp as a platform and others allow you to have that anonymity, and what the bill does in particular is that it allows us to protect that anonymity, and then at the very least the plaintiff or the party that originally is filing the suit would have to take the steps of presenting some sort of evidence to actually show that it's necessary to breach that anonymity. We actually dealt with a case in Virginia that was sort of along these lines, where the Hadid carpet cleaning company filed a motion to get Yelp to breach the anonymity of 7 individuals who'd posted negative reviews about their business. We fought it, and honestly, we actually lost the first 2 times in Virginia in the state court process because of the quirkiness of Virginia law, and it sort of comes back to, the laws not being up to date within the state and basically threatening the anonymity of these individuals who we knew were real. We'd actually had the opportunity to speak with them, and I ended up meeting one of them outside of the job randomly, and these were real firsthand experiences. But we had to take it to the Supreme Court in Virginia, and ultimately we didn't win on substantive grounds. We did win, though, but we basically won on venue. Basically, the court saying that the Hadid carpet cleaning company should have filed its claim in California because we're a California-based company. But what we like about the Speak Free Act as well is that it still allows us to protect the anonymity of our users, or if you are on other platforms where you decide to anonymously post, and it still does allow for the business to, if they are able to provide the evidence there, to prove and to get the access to that person's information, but at least there are processes in place that provide you or I with greater protections.
I just want to echo a point about what Laurent said, that this idea, once again, of David versus Goliath, and that these suits are meritless. Nothing in the Speak Free Act limits its scope to those kinds of lawsuits. Nothing limits it to meritless lawsuits or lawsuits where there's this great disparity between parties. So I think that's something to consider. Now, we're talking about anonymous reviews now. So I'm guessing the part of the Speak Free Act that you're talking about that helps companies like Yelp would be the motion to quash for the personally identifiable information. We didn't have any opposition to that provision in the bill, just so that's clear. We were concerned about mostly the scope of this bill, how it is designed to quickly and with prejudice get rid of these lawsuits, and that the scope is so broad that you're capturing cases that you're not meaning to, such as slap lawsuits. Cases like Monique Rathbuns, where she had a legitimate harassment lawsuit that she's now having to spend tons of resources and appellate counsel on to try to fight what is essentially a meritless slap motion.
So we promised to get you out quickly. This is a flash briefing. So we have 10 more minutes. We'd like to open it up to questions if anyone has. We should have a roving mic. Yes, in the white jacket. So the question is quantifying how big the problem is.
I have some statistics only for California, and I'm going to admit right now I will read through my notes because there's no way I was remembering all of this. Between 2005 and 2010, the Judicial Council of California notes that parties reported a total of 2,881 anti-SLAPP motions in trial courts throughout California. or roughly 481 motions per year. During that 6-year period, an appeal was filed in only 375 of those cases, 13 at the time. So, put another way, in nearly 90% of the cases, no anti-SLAPP appeal was filed. And that's sort of, given that there were about 6.2 million civil filings in superior courts during that period, the 2,881 anti-SLAPPs constitute only about, 0.046% of all lawsuits. That's just California.
I think that's a really good question, too, because that's for California. We don't know. This bill is a federal bill. It applies to federal courts. We don't know anything about how many of these SLAPP lawsuits are being filed in other states and in federal courts. So I think it's a good question to ask that before we pass legislation that's going to circumvent the Rules Enabling Act and also expand the jurisdiction of federal courts, is how big of a problem is this?
I think
I'm sorry, go ahead.
One thing to keep in mind, though, is that a SLAPP that is filed in court and that is moving forward, that is generally the last step of the process that we're talking about here. It's not that you immediately say you're going to file a SLAPP suit and then file it, against the person who wrote a review or made a statement online. You generally let it linger and have your attorney basically go through this whole intimidation process to try to get the statement either retracted or to get the review removed before you actually, as the plaintiff, even bother filing in federal court. So when you look at that number isn't really indicative of the overall threat and the chilling effect that's happening.
And I would say, as in this world that's constantly changing, I find this anti-SLAPP very critical to our society. The ability to speak and the ability to speak freely, and for individuals to have opinions and to not be threatened, and that chilling effect, which you can imagine taking place, fairly quickly, unless that we come together and say this, you're not allowed to threaten to sue me because I wrote about your carpet company. Those 7 individuals probably aren't going to be posting many more reviews. So I think that we have an opportunity now to take a look at communication and allow people their opinions, not only media organizations, but individuals, and that's where I see the import of what we're looking at to pass this.
Also, just to provide a little bit of context, because we're having, I think, a very good and thoughtful conversation about anti-SLAPP or SLAPP suits in general, and also about the Speak Free Act. But in regards to the Speak Free Act in particular, while the AAJ has expressed concerns about the bill, there was recently a letter that was actually sent to Congress, to the Judiciary Committee, that had about 35 different organizations and groups in support. And these were folks obviously like Yelp, TripAdvisor, Zenefits, Glassdoor.com, groups such as Public Knowledge, the Center for Democracy and Technology, the R Street Institute, FreedomWorks. These are folks on both the left and the right, and even the National Association of Broadcasters that said that they support the Speak Free Act and that they want the bill to move forward in Congress. And even that's just specifically in regards to the Speak Free Act. On the issue of federal anti-SLAPP legislation, there are even more companies and organizations out there that have said that they support federal anti-SLAPP legislation, and even on the state level as well that have been promoting it. You have organizations like the NPAA that have been going around supporting state anti-SLAPP bills in different jurisdictions as well. So when you sort of look at this bill and this issue, it's really one that's united a lot of groups that traditionally have been on the opposite sides of the debate here in Congress.
I want to reiterate that point too. That on the issue of supporting SLAPP legislation, both of who's in support and who's against, many of AAJ's state affiliates have actually supported SLAPP legislation at the state level. So I don't think this is not to say, I don't want my testimony to be taken here today as that there's no solution here, turn around and go home. I think it's that the devil's in the details, and that you're getting into a very careful balance of constitutional rights here. So that I think this discussion, which is worthy and very important, should have a lot of creative thinking and should any solution should be narrowly tailored and carefully crafted to make sure that it affects slap lawsuits and nothing but slap lawsuits.
I'm sure it would be a deterrent, but I also think that would be perhaps a truly overbroad solution to the problem. I mean, it should be clear now that we don't all agree on we agree on the concept, we don't all agree on the details, and one of the differences I think we have is that I don't think this is necessarily overbroad. I don't think it goes too far beyond slap suits. I'm sure there will be instances of where people are caught up in a slap situation and the little guy really does lose out even where the anti-slap statute exists. I'm sure that will happen. It will be unfortunate. And I do think that on the whole, we would look to preserve free speech rights with a broad Speak Free Act and thereby protect more people. And because there have clearly been a number of people that have been subjected to slap suits. Well, you've given one example. I know you would have a lot. We could come back with our own. I think we all agree. And it goes back to what I said earlier about the balancing. We both agree on that. There's a sort of balancing test that you have to come into where you balance everybody's rights. And I think we're just sort of on different sides of that tilt. But I do think that adopting full scale the English rule for me would be too far.
I want to chime in really quickly on this because I want to make sure to get this point in there because I think it's important, especially in regards to what was discussed earlier. So you mentioned in Texas sort of the Church of Scientology and them filing an anti-slap motion there and having it really sort of tied up in, I guess, at the appellate level of discovery. It's my understanding, though, that with the Speak Free Act, that there's actually language in the bill as well that if you are the defendant and you frivolously file an anti-slap motion, that you would still be forced to pay some sort of fee or restitution.
Right. And that's what I was going to get at. It does allow the judge to impose that. Not the full English rule for all cases. Now I see what you're saying is would you adopt the fact that the losing party pays in an anti-slap? And it does exist in the Speak Free Act. And I don't think it's not that it's always going to be the full attorney's fees. It's not that it's always going to be in every case. But it does create that right, which is extremely valuable, probably more valuable as a deterrent than simply saying the case will be accelerated and kicked out more quickly.
And I think this is a good point when you talk about is it enough to deter true slappers or true people who are abusing the court system? And the problem is that it deters the Davids, but it doesn't deter the Goliaths. The Goliaths have the money to pay sanctions, to pay the other side's attorney's fees. It doesn't prevent them, and that's what you're really trying to get at here. It does have a chilling effect on Davids, particularly Davids that are presenting novel theories under the law. There was a time in our country when the theory under Brown versus Board education was considered extremely novel, and they won. That doesn't mean that had they lost, which was a big risk that counsel took, they should have paid someone else's attorney's fees. I think imposing that kind of English rule on our American system would have a significant chilling effect on all litigants. And we had something similar to that from 1983 to 1993 in the federal rules. It created a ton of side litigation on this satellite issue of what's frivolous and what's not. I mean, the counsel was someone would file a Rule 10 sanctions motion, and then you would immediately file another Rule 10 sanctions motion in response to their Rule 10 sanctions motion saying, oh, well, this is frivolous that they're calling me frivolous. So it got out of hand, and the judicial conference, the federal judges actually opposed it and asked Congress to change it back so that back to the original American rule. So I think that's an excellent question. It's this threat of that you having to pay another attorney's fees is significant, but it's significant to the Davids, not the Goliaths. And that's who we're trying to prevent here, is the Goliaths, who are going after reporters and Yelp reviewers, people who really don't have the resources to fight them in a court of law.
Speaking of Goliaths, though, I want to give one more example, and I realize we're almost out of time here, but that really, I think, helps to go to the heart of why you need federal anti-slap legislation, and it involves the state of Nevada. So Nevada, for about a year and a half, has had a really good anti-SLAPP law in the books, or had a really good anti-SLAPP law in the books. And a resident in Nevada, and hopefully he doesn't listen to this or hear this, because, then I'll have to hire one of you guys, Steve Wynn. So Steve Wynn lost a lawsuit, a defamation suit in California on, I think it was March 4th. Don't exactly quote me on the day, but I want to say around March 4th, based off of an anti-SLAPP motion. So he lost it in the state of California, and then, though, about 3 weeks later, around March 20th or 21st, in the state of Nevada, there was a bill introduced in the state legislature to gut the anti-SLAPP law that Nevada had had on the books for less than 2 years. And who was it supported by fully? Who was it really backed by? It was backed by Wynn Industries, Steve Wynn's company. And so this bill was introduced, and in less than 3 weeks afterwards, already passed the Nevada State Senate. It passed the Senate. It was over in the Nevada House. Companies like Yelp and TripAdvisor and others were scrambling. A lot of sort of First Amendment freedom of speech groups were scrambling in the state to try to help to slow this process and stop what was otherwise going to be a bill that was going to gut the rights of Nevadans to speak freely online. And thankfully, eventually, we were able to work towards a compromise that still really kept the core of the Nevada law. But it kind of goes to the point of when you've got this, when you're talking about Goliaths and you've got, a billionaire casino mogul who literally goes and, works to get the law of the state changed in order to protect the interests of people like him. This really goes to say that if you can have that much sort of a fluctuation in regards to legislation that will impact the ability of people to speak freely online and to share their opinions, why you need a federal minimum standard here. And that's what the Speak Free Act does.
I know we're right at time. I want to reframe this David versus Goliath discussion in a different way. And by doing so, bring it back to where we started. You talked about it in terms of, will the attorney's fees be a deterrent to Goliath from bringing the suit because, will this hurt them in any way? No. That's not the point, though. The point is Daniel Snyder saying, indeed, the cost of litigation will presumably quickly outstrip the asset value of the Washington City paper. And so he thinks the city paper will roll over instead, in the face of having to pay the litigation fees. But guess what? Now they don't. If they believe they have a merited case and they're going to win and they can get their attorney's fees back, then they are finally willing to go to court and fight. And that's the way you have to look at it, that the penalty isn't on the person suing. The benefit comes back, or the deterrent effect is that you're pushing on them, you're hitting them, is not going to make an impact at all.
All right, thank you all. On behalf of the Congressional Internet Caucus and the Advisory Committee, really great discussion here. The Twitter information, like we said, is on the programs if you want to get in touch with anyone for more information. A number of organizations have reports floating around about this issue, and we encourage you to look into it further and come to our events for the rest of the month of July.